From supplementary list for pronouncement of judgment.
We referred copiously to the impugned judgment. To various paragraphs, we picked them up and showed how, as we say, it was demonstrably unsustainable, the judgment. We'll read out some parts. Even the Evidence Act indicates that admission is the best form of proof. When so much is admitted by the accused persons as evident from the independent statements of Bernard and Bonney, which is also corroborated by other evidence and record, there is little else that the trial court had to look into. Both Bernard and Bonney gave similar accounts of what they did in the late afternoon and evening of February 18, the places they visited and where they finally ended up. The extent of the statements matching each other is quite remarkable, even in their details. On a combined reading of the two statements, it is evident that all three of them may have been drunk by the time they reached the quiet surroundings of the graveyard in Mauro, with Biplop being the worst affected. The statements are consistent to the extent that Bernard went out to get a cigarette. The best part of the statements is that each speaks of Biplop's shoes being removed and the soles of his feet being massaged to revive him. Quite frankly, even though the material pertaining to the charge of kidnapping for ransom may not have been presented, the fact that the three had travelled to Mauro, the fact that Bernard was present at the relevant PCO around the time that Biplop made a call there from, and further that Bernard and Bonney were with Biplop when he met his unnatural death, were clearly established. In the light of the overwhelming evidence in respect of the material incident, there were only a few dots to join and no room for any doubt. As to the charge under Section 201 IPC for causing disappearance of evidence of offence, the voluntary statements of Bernard and Bonney match each other and give a detailed picture of how they disposed of the body upon discovering that Biplop had died. This part of the statement is consistent with the subsequent recovery of the body, albeit it not being clear as to who led the police to where the body was buried. It is not for the court to conjecture as to what may have prompted Bernard or Bonney to record their statements. Even in this day of advanced science and medicine, human intelligence has not been able to decipher exactly what makes the brain tick or exactly what impels a person to act in a particular manner. At the time that their statements were recorded under 164 of the Code, Bernard and Bonney had been arrested and interrogated. It is more than probable that both the respondents herein found themselves to be in a helpless situation where they could not altogether dissociate themselves from the circumstances leading to the disappearance and death of Biplop. Even though a statement by an accused in such circumstances has to be regarded as a sort of confession, there was no real confession in either statement of having committed an offence. It is more than possible that when Bernard and Bonney found themselves cornered with all the material against them, their guilty minds may have prompted them to furnish a believable explanation as to the circumstances in which the two were with the victim immediately prior to and at the time of the victim's death. In making such statements, both Bernard and Bonney steered clear of admitting that they had plotted or intended to kidnap Biplop for ransom, or they had plotted or intended to murder Biplop. The tenor of the statements is such that the admission of the offence is confined only to the charge under Section 201 IPC, and the attempt at explanation in such regard is that they may have been taken aback by the dramatic turn of events and decided to conceal the body rather than report the matter to the police. Bernard did one better. He blamed Bonney for the death of Biplop. Bonney had no credible explanation to offer as to how Biplop died. And there is no doubt that both respondents herein were into the matter together and acted as one. There is also admission to the extent that they wanted money from Biplop, but though no admission of kidnapping for ransom was made by either. In a sense, both the statements appear to be cleverly crafted, admitting only to the extent absolutely unavoidable in the circumstances. rather than the statements being of confession of the primary offences that they were charged with, both the accused persons made an attempt to extricate themselves, except that no credible answer as to the unnatural death of Biplab was presented. Therein lay the fallacy of the exercise, and the trial court completely misdirected itself in not even referring to the essence of the statements or trying to glean any meaning therefrom. Then we've dealt with the matter pertaining to Section 34 not being included. Then we have said that the trial court failed to see the PCO records. And then finally, we have found all of this against you. On the basis of material presented by the prosecution at the trial, it was clearly established from the statements of Bernard and Bonnie that they had been drinking at some place in Polo in the evening of February 18. From the statement of the auto rickshaw driver that Bernard and Bonnie and a non-tribal boy were driven by him the same evening from Polo to Mauro. From the evidence of Nirvika and the phone bill of the PCO that a call was made to Nirvika's number from a PCO in Mauro at 8:18 p.m. on the same day. From the statement of the PCO owner to Roger Sangma that Bernard was at the PCO in the evening of the same day, and finally from the statements of Bernard and Bonnie that they were both with Biplab just before and at the time of Biplab's death in the graveyard at Mauro. In addition, the respondents revealed how they had disposed of the dead body, and as a matter of fact, the dead body was found buried in the same graveyard before it was exhumed and examined. The other matters, including who led to the discovery of the body and the alleged murder weapon, despite the inconsistencies therein, had to be regarded as secondary compared to the primary material that was available and established. Even if no case was made out of kidnapping for ransom or any obvious motive, that would not be fatal for the prosecution, as long as the circumstances indicate the culpability of the accused persons beyond reasonable doubt. The trial court lost its way in minor details and failed to see the larger picture. We've recorded all the law that you have cited, both sides, only the judgments actually cited, and then we have said that hopefully we have lived by the test that you showed, the judgment that when you reverse an acquittal, the findings of the trial court have to be found to be palpably wrong, manifestly erroneous, and demonstrably unsustainable. We have said that we've also referred to circumstantial evidence, and we finally hold. In the circumstances, the judgment and order impugned dated 26 March are reversed. The respondents are found guilty and convicted under Section 302, read with 201 IPC, for the murder of Biplab Das and concealment of evidence thereafter. There was a common intention. Accordingly, both the respondents are found guilty of committing murder and concealing the evidence of the offence. Since this is not a rarest of rare case, both the respondents are sentenced to life imprisonment under Section 302 IPC and 3 years of rigorous imprisonment under Section 201. The sentences would run concurrently in the sense that the respondents will serve rigorous imprisonment in the first 3 years and continue to remain in prison thereafter for life. It was a dastardly act that had been plotted out with the common intention of obtaining money from the victim, whether or not it was by way of extortion or by kidnapping for ransom, and the victim died a gruesome death as a result of the plan executed by the respondents. It is only just that the respondents face the appropriate consequences for their acts. The respondents will be taken into custody immediately for serving out the sentences in accordance with law. The lower court records be immediately sent down. Authenticated copies be made available immediately, free of cost. Yes, madam. That's it. Thank you.
Obliged, Lord. Obliged, Lord.
Obliged, Lord.
Yeah. We'll sign the individual pages because it will take a long time.
Sent to whom? Your Lordship, with only a small clarification. Normally, whenever a judgment is passed, the sentence hearing is always done separately.
Sentence?
The sentence hearing, as per section CRPC 235.
There's no choice over here.
Absolutely, Lordship.
There's no choice. We are giving them the least of the thing. That's why we don't have to hear them on sentence.
Absolutely, Lordship. So, only thing is this, that may be recorded because the counsels are here.
Yes, there's no question of.
Lesser punishment, Lordship, is correct.
We've given the least punishment. The choice is between life and death. We've said this is not a rare case. We've given them this, so there's no question of hearing on sentence.
I just thought, Lordship,
302.
Lordship is. So I thought just pointed out because
Yes.
Normally 235 says, Lordship, hearing of sentence is mandatory.
Yes.
So if that can be observed,
We'll just add one line.
Lordship, please. Otherwise, there is a Supreme Court judgment, Lordship, only in that matter, the matter was remanded back.
Yes, we'll just add one.
Please, Lordship.
Thank you. Thank you.
Obliged, Lordship.